Good morning, attorney. Good morning, classmates. We are Group 6 and we are here to report on our assigned cases. Uh, Group 6 members Irvin Carl Fortes, Jacob Suarez, Andrea Trazoda, and Jezamel Vista. As the first reporter, here are my list of cases. First is Penera versus Comelec under election laws. Second is Agustin versus Comelec under candidacies and eligibilities of candidates. Number three is Tagolino versus HRET under candidacies and eligibilities as well. And my last case would be Lagasca versus Comelec under candidacies and eligibilities of candidates. The first case is Penera versus Comelec et al., which is penned last November 25, 2009, and under the topic on election laws. The facts of the case are as follows. Rosalinda Penera and private respondent Edgar T. Andanar were mayoralty candidates in Santa Monica, Surigao del Sur during the May 14, 2007 elections. On April 2, 2007, Andanar filed before the office of the Regional Election Director of the Caraga region a petition for disqualification against Penera, as well as the candidates for Vice Mayor and Sangguniang Bayan who belonged to her political party, for unlawfully engaging in election campaigning and partisan political activity prior to the commencement of the campaign period. Penera filed a motion for reconsideration of this court's decision of September 11, 2009. The assailed decision dismissed Penera's petition and affirmed the resolution dated July 30, 2008 of the Comelec Unbank, as well as the resolution dated July 24, 2007 of the Comelec Second Division. The decision disqualified Penera from running for the office of mayor in Santa Monica, Surigao del Norte, and declared that the vice mayor should succeed Penera. In support of her motion for reconsideration, Penera submits the following arguments. First, that Penera was not yet a candidate at the time of the incident. Second, the petition for disqualification failed to submit convincing and substantial evidence against Penera for violation of Section 80 of the Omnibus Election Code. Three, Penera never admitted the allegations of the petition for disqualification and has consistently disputed the charge of premature campaigning. And fourth, the admission that Penera participated in a motorcade is not the same as admitting she engaged in premature election campaigning. The issues of this case is or are whether or not Penera is guilty of premature campaigning, and the second issue being whether or not premature campaigning can be committed by a person who is not a candidate. The ruling of the Supreme Court is no to both. Under the assailed decision of September 11, 2009, a candidate may already be liable for premature campaigning after the filing of the certificate of candidacy, even before the start of the campaign period. Thus, such person can be disqualified for premature campaigning for acts done before the start of the campaign period. In short, the decision considers a person who files a certificate of candidacy already candidate even before the start of the campaign period. Now, the court holds that the assailed decision is contrary to the clear intent and letter of the law. In Lanot versus Comelec, it was held that a person who files a certificate of candidacy is not a candidate until the start of the campaign period. Lanot was decided on the ground that one who files a certificate of candidacy is not a candidate until the start of the campaign period. Congress elevated the Lanot Doctrine into a state statute by specifically inserting it as the second sentence of the third paragraph of the amended Section 15 of RA 84 936. In RA 9369, Congress inserted the word only so that the provision now reads, provided that unlawful acts or omissions applicable to a candidate shall take effect only upon the start of the aforesaid campaign period. Thus, Congress not only reiterated but also strengthened its mandatory directive that election offenses can be committed by a candidate only upon the start of the campaign period. This clearly means that before the start of the campaign period, such election offenses cannot be so committed. In layman's language, this means that a candidate is liable for an election offense only for acts done during the campaign period and not before. The law is clear as daylight. Any election offense that may be committed by a candidate under any election law cannot be committed before the start of the campaign period. In ruling that Penera is liable for premature campaigning for partisan political acts before the start of the campaigning, the sale decision ignores the clear and express provision of the law. The second case is Agustin versus Comelec et al., penned last November 10, 2015. The facts of the case are as follows. In 1997, petitioner Agustin was naturalized as a citizen of the United States of America. In 2012, he filed his certificate of candidacy for the position of mayor of the municipality of Marcos, Ilocos Norte, to be contested in the May 2013 local elections. As the official candidate of the Nacionalista Party, he declared in his COC that he was eligible for the office he was seeking to be elected to, that he was a natural-born Filipino citizen, and that he had been a resident of the municipality of Marcos, Ilocos Norte for 25 years. Respondent Salvador Espillos, a rival mayoralty candidate, filed in the Comelec a petition to deny due course and or to cancel the certificate of candidacy of Agustin, alleging that the petitioner had made a material misrepresentation in his candidate certificate of candidacy by stating that he had been a resident of the municipality of Marcos for 25 years, despite having registered as a voter therein only on May 31, 2012. In his answer, petitioner countered that the one-year requirement referred to residency, not to voter registration, and that residency was not dependent on citizenship, such that his travel to Hawaii for business purposes did not violate the residency requirement pursuant to the prevailing jurisprudence. And that as regards citizenship, he attached a copy of his affidavit of renunciation of U.S. American citizenship. The Comelec Second Division issued its omnibus resolution holding that the requirement that a candidate must be a registered voter does not carry with it the requirement that he must be so 1 year before the elections, because this refers to the residency qualification. As far as registration as a voter is concerned, it should suffice that they are duly registered upon the filing of their COCs or within the period prescribed by law for such registration. Pilios moved for the reconsideration with the Comelec en banc. He alleged that the certification issued by the Bureau of Immigration reflected that the petitioner had voluntarily declared in his travel documents that he was a citizen of the United States. That when he traveled to Hawaii on October 6, 2012, he still used his USA passport, despite renunciation of his US citizenship on October 2, 2012, and after filing his COC on October 5, 2012, in which he declared that he was a resident of the municipality of Marcos, Ilocos Norte, and that the petitioner's declaration of his eligibility in his COC constituted material misrepresentation because of his failure to meet the citizenship and residency requirements. On April 23, 2013, the Comelec and Bank issued its assailed resolution canceling and denying due course to the petitioner's COC, observing that while Agustin presented a copy of his affidavit of renunciation, he failed to furnish the commission a copy of his affidavit of his attached. However, said attachment is not has not been made available for the perusal of the commission. Having failed to sufficiently show that he complied with the provisions of RA 9225, Agustin's Comelec Agustin COC must be cancelled and or denied due course. On election day, the name of the petitioner remained in the ballot. He was later on proclaimed as the duly elected municipal mayor of Marcos, Ilocos Norte, garnering the highest votes among the contending parties. The petitioner filed on an urgent motion to withdraw verified urgent motion for reconsideration with leave of court. The petitioner then instituted this case, alleging grave abuse of discretion amounting to lack or excess of jurisdiction on part of the Comelec and Bank. The issues of the case are as follows. First is whether or not petitioner Agustin is eligible as a candidate for the position of mayor of Marcos, Ilocos Norte. Second is whether or not Pilios' claim that he is the rightful occupant of the contested elective position is correct. The ruling for the first issue is no. Agustin is not eligible as a candidate for the position of mayor of the municipality of Marcos, Ilocos Norte. The petitioner filed a valid certificate of candidacy, but the use of his U.S. passport after his renunciation of foreign citizenship rendered him disqualified from continuing as a mayoralty candidate. There are two remedies available under existing laws to prevent a candidate from running in an electoral race. One is by petition for disqualification, and the other by petition to deny due course or to cancel his certificate of candidacy. A petition for disqualification can be premised on Section 12 or Section 68 of the Omnibus Election Code or Section 40 of the Local Government Code. On the other hand, a petition to deny due course to or cancel a COC can only be granted on a statement of a material representation in the said certificate that is false. The petitions also have different effects. While a person who is disqualified under Section 68 is merely prohibited to continue as a candidate, the person whose certificate is cancelled or denied due course under Section 78 is not treated as a candidate at all. It is as if he or she never filed a certificate of candidacy. Section 78 of the Omnibus Election Code, therefore, is to be read in relation to the constitutional and statutory provisions on qualifications or eligibility for public office. If the candidate subsequently states a material representation in the COC that is false, the Comelec, following the law, is empowered to deny due course to or cancel such certificate. The petition of Pilios was in the nature of the Section 78 petition to deny due course to or to cancel the certificate of candidacy of Agustin. The Comelec and Bank canceled the petitioner's COC not because of his failure to meet the residency requirement, but because of his failure to sufficiently show that he complied with the provisions of RA 9225. Such basis for cancellation was unwarranted, considering that he became eligible to run for public office when he expressly renounced his U.S. citizenship, by which he fully complied with the requirements stated in Section 5, Paragraph 2 of RA 9225. His COC was valid for all intents and purposes of the election laws, because he did not make therein any material misrepresentation of his eligibility to run as mayor of Marcos, Ilocos Norte. The court upheld the declaration by the Comelec and Bank that the petitioner was ineligible to run and be voted for as mayor of the municipality of Marcos, Ilocos Norte. It is not disputed that on October 6, 2012, after having renounced his U.S. citizenship and having already filed his COC, he traveled abroad using his U.S. passport, thereby representing himself as a citizen of the United States. He continued using his U.S. passport in his subsequent travels abroad, despite having been already issued his Philippine passport on August 23, 2012. He thereby effectively repudiated his oath of renunciation on October 6, the first time he used his USA passport after renouncing his US citizenship on October 2, 2012. Consequently, he could be considered an exclusively Filipino citizen only for the 4 days from October 2, 2012 until October 6, 2012. The petitioner's continued exercise of his rights as a citizen of the United States through using his U.S. passport after the renunciation of his U.S. citizenship reverted him to his earlier status as a dual citizen. Such reversion disqualified him from being elected to public office in the Philippines pursuant to Section 40 of the Local Government Code. As for the second issue, the Supreme Court ruled that yes, Pilisa's claim that he is the rightful occupant of the contested elective position, which is the seat of the mayor of Marcos, Ilocos Norte, is correct. Petitioner was declared disqualified by final judgment before election day. Hence, the votes cast for him should not be counted. His rival, Pilios, should be proclaimed the duly elected mayor for obtaining the highest number of votes in the elections. The effect of the petitioner's disqualification under the April 23, 2013 resolution depended on when the disqualification attained finality. The distinction exists because of Section 6 of the Electoral Reforms Law of 1987, which states that any candidate who has been declared by final judgment to be disqualified shall not be voted for, and the votes cast for him shall not be counted. If for any reason a candidate is not declared by final judgment before an election to be disqualified, and he is voted for and receives the winning number of votes in such election, the court or commission shall continue with the trial and hearing of the action, inquiry, or protest, and upon motion of the complaint or any intervener may during the pendency thereof order the suspension of the proclamation of such candidate whenever the evidence of his guilt is strong. Section 6 of the said law covers two situations. The first is when the disqualification becomes final before the elections, which is the situation covered in the first sentence of Section 6. The second is when the disqualification becomes final after the elections, which is the situation covered in the second sentence of Section 6. The present case falls under the first situation. Section 6 of the Electoral Reforms Law governing the first situation is categorical. A candidate disqualified by final judgment before an election cannot be voted for, and votes cast for him shall not be counted. The effect was to render the votes cast in his favor stray, resulting in Pilias being proclaimed the winning candidate. It is crucial, therefore, to determine with certainty the time when the judgment declaring the petitioner disqualified from running for the local elective position attained finality. Pilias submits that the April 23, 2013 resolution was already deemed final and executory as of May 4, 2013. Hence, the writ of execution was issued on June 18, 2013. And the petitioner's disqualification thus attained finality prior to the May 2013 elections. Pulis's submission is correct, although the petitioner filed his verified urgent motion for reconsideration with leave of court. The April 2013 resolution granting Pulis's motion for reconsideration, such filing did not impede the April 2013 resolution from being deemed final and executory because Section 1D, Rule 13 of the 1993 Comelec Rules of Procedure expressly disallowed the filing of the motion for reconsideration. Within the context of Section 13, Rule 18, and Section 3, Rule 37, both of the 1993 Comelec Rules of Procedure, the April 2013 resolution became final and executory as of May 4, 2013, upon the lapse of 5 days from its promulgation without a restraining order being issued by the Supreme Court. The third case is the case of Tagolino versus the House of Representatives Electoral Tribunal. And the facts are as follows. On November 30, 2009, Richard Gomez filed his certificate of candidacy with the Commission on Elections, seeking the congressional office as representative for the 4th Legislative District of Leyte under the ticket of the Liberal Party. Subsequently, on December 6, 2009, one of the opposing candidates, Buenaventura Puntilla, filed a verified petition alleging that Richard, who was actually a resident of College Street, East Green Hills, San Juan City, Metro Manila, misrepresented in his certificate of candidacy that he resided in 910 Carlota Hills, Canadieng, Ormoc City. In this regard, Puntilla asserted that Richard failed to meet the one-year residency requirement under Section 6, Article 6 of the 1987 Philippine Constitution, and thus should be declared disqualified or ineligible to run for the said office. In addition, Puntilla prayed that Richard's COC be denied due course and or cancelled. On February 17, 2010, the Comelec First Division rendered a resolution granting Puntilla's petition without any qualification. Aggrieved, Richard Gomez moved for reconsideration, but the same was denied by the Comelec en banc through a resolution dated May 4, 2010. Thereafter, in a manifestation of even date, Richard accepted the resolution with finality in order to enable his substitute to facilitate the filing of the necessary documents for substitution. On May 5, 2010, Lucy Marie Torres Gomez, the wife of Richard Gomez, filed her COC together with a certificate of nomination and acceptance, or CONA, from the Liberal Party, endorsing her as the party's official substitute candidate vice her husband for the same congressional post, in response to various letter requests submitted to the Comelec's Law Department. The Comelec en banc, in the exercise of its administrative functions, issued Resolution number 889011 on May 8, 2010, approving, among others, the recommendation of the said department to allow the substitution of private respondent. The substitution complied with the requirements provided under Section 12 in relation to Section 13 of Comelec Resolution number 8678, dated October 6, 2009. In view of the foregoing, the Law Department recommended to allow candidate Lucy Torres Gomez as substitute candidate for Richard Gomez. The issue in this case is whether or not there is a valid substitution. The ruling of the Supreme Court says that no, Lucy Torres did not validly substitute Richard Gomez. Misrepresentation warrants cancellation of the certificate of candidacy and not disqualification. When cancelled, there is no valid COC. As such, there is no candidate. Ergo, there cannot be substitution And substitution is proper only when the substituted is disqualified because he or she was considered a candidate until ordered.
Good afternoon, attorney. Good afternoon, classmates. I'm Jacob Suarez. To continue with the reporting, it will tackle the cases of Santos versus Comelec, Halili versus Comelec, Cayat versus Comelec, and Panlaqui versus Comelec. So for the first case, it's Santos versus Comelec. For the doctrine of the case, when a candidate is declared a nuisance candidate, it certainly follows that he or she cannot be voted for, as he or she is not a candidate. Consequently, the vote shall be credited to the legitimate candidate. Evidently, the crediting of the votes is a logical consequence of the final decision in the nuisance case, because the vote for the nuisance candidate is considered a vote for the legitimate candidate. In a nuisance petition, the votes of the nuisance candidate shall be credited to the legitimate candidate once the decision becomes final and executory, whether before or after the elections. So for the facts of the case, respondent Jennifer Rojas filed a certificate of a candidacy for the position member of the Sangguniang Panlungsod for the 1st District of Pasay. She filed a petition for disqualifications against Rosalie Rojas on the ground of being a nuisance candidate and because her certificate of candidacy was filed for the sole purpose of causing confusion among the voters by the similarity of their names. In its resolution, the Comelec granted the petition and declared Rosalie a nuisance candidate. Rosalie filed a motion for reconsideration before the Comelec. The top 6 candidates were proclaimed as duly elected members of the 1st District of the Sangguniang Panlungsod of Pasay City. Respondent was not included because she ranked in 7th place, while Rosalie ranked in 14th place, garnering 13,328 votes. Respondent filed an election protest against Santos before the Comelec on the ground that the votes for Rosalie, who was declared a nuisance candidate, be credited to her, that the proclamation of Santos as a member of the Sangguniang Panlungsod for the 1st District of Pasay be annulled, and that she be proclaimed as the winning candidate. The Comelec en banc issued a resolution denying Rosalie's motion for reconsideration. The following are the issues of the case: whether or not Rosalie Rojas was a nuisance candidate, and whether or not the votes of Rosalie should be added to respondent. The ruling of the court is yes. The court held that a petition for disqualification of a nuisance candidate clearly affects the voters' wills and causes confusion that frustrates the same. This is precisely what election laws are trying to protect. They give effect to, rather than frustrate, the will of the voter. The declaration of a duly registered candidate as a nuisance candidate results in the cancellation of its COC. The law mandates the Comelec and the courts to give priority to cases of disqualification to the end that a final decision shall be rendered not later than 7 days before the election in which the disqualification is sought. The court cited the case of Martinez versus HRET, wherein it held that laws and statutes governing election contests, especially appreciation of ballots, must be liberally construed to the end that the will of the electorate in the choice of public officials may not be defeated by technical infirmities. The prohibition against nuisance candidate is aimed precisely at preventing uncertainty and confusion in ascertaining the true will of the electorate. Thus, in certain situations, final judgments declaring a nuisance candidate should effectively cancel the certificate of candidacy filed by such candidate as of election day. When a candidate is declared a nuisance candidate, it certainly follows that he or she cannot be voted for, as he or she is not a candidate. Consequently, the votes shall be credited to the legitimate candidate. The crediting of the votes is a logical consequence of the final decision in the nuisance case because the vote for the nuisance candidate is considered a vote for the legitimate candidate. In a nuisance petition, the votes of the nuisance candidate shall be credited to the legitimate candidate once the decision becomes final and executory, whether before or after the elections. In this case, as early as October 21st, 2015, respondent filed a petition to declare Rosalie a nuisance candidate because she chose the name Rojas Genros to appear. So for the next case is Halili versus Comelec. The facts of the case is Petitioner Morales was elected as mayor of the municipality of Mabalacat for 3 consecutive terms, 2007, 2010, and 2013. On his second term, the municipality of Mabalacat became a component city. 2016 elections, he filed the COC for the position of mayor of Mabalacat City. Respondent Lucas, also a candidate for the same petition, filed a petition for cancellation of the COC and or disqualification of Morales. Lucas alleged that Morales was disqualified to run for mayor since he was elected and had served 3 consecutive terms prior to the 2016 elections. Morales insists that his second term as mayor of the municipality of Mabalacat was interrupted by the conversion of the municipality into a component city. Morales claims that Mabalacat City is an entirely different political unit from the municipality of Mabalacat, having an increased territory, income, and population. So the issue in this case is whether or not the conversion of the municipality of Mabalacat into Mabalacat City interrupted Morales' services for the full term for which he was elected. So the court ruled that no, there are 2 conditions which must concur for the application of the disqualification of a candidate based on violation of the 3-term limit rule. Number one, that the official concerned has been elected for 3 consecutive terms in the same local government post, and that he has fully served 3 consecutive terms. Citing the case of Latasa versus Comelec, Latasa, the SC held that the conversion of a municipality into a city does not constitute an interruption of the incumbent official's continuity of service. We held that to be considered as interruption of service. The law contemplates a rest period during which the local elected official steps down from office and ceases to exercise power of authority over the inhabitants of the territorial jurisdiction of a particular local government unit. Applying our ruling in Latasa, the provisions of RA 10164 mean that the delineation of the metes and bounds of Mabalacat City did not change even by an inch the land area previously covered by the municipality of Mabalacat. Consequently, the inhabitants are the same group of voters who elected Morales to be their mayor for 3 consecutive terms and over whom he held power and authority as their mayor. Accordingly, Morales never ceased from acting and discharging his duties, excuse me, and responsibilities as chief executive of Mabalacat, despite the conversion of the municipality of Mabalacat into Mabalacat City. So for the next case is Cayat versus Comelec. The facts of the case is Father Nardo Cayat and Thomas Palileng are the only mayoralty candidates for the May 2004 elections in Baguias, Benguet. Palileng filed a petition for cancellation of the COC of Cayat on the ground of misrepresentation. Palileng argues that Cayat misrepresents himself when he declared in his COC that he is eligible to run as mayor, when in fact he is not because he is serving probation after being convicted for the offense of acts of lasciviousness. Comelec granted the petition of Paliling and Cayat filed a motion for reconsideration. Such MR was denied because Cayat failed to pay the filing fee and hence it was declared final and executory. Despite this decision, Cayat was still proclaimed as the winner and Paliling filed a petition for annulment of proclamation. Comelec declared Paliling as the duly elected mayor and Feliceo Bayaksan as the duly elected vice mayor. Bayaksan argues that he should be declared as mayor because of the doctrine of rejection of second placer. The issue in the case is whether or not the rejection of second placer doctrine is applicable. It was ruled that the doctrine cannot be applied in this case because the disqualification of Cayat became final and executory before the elections and hence there is only one candidate to speak of. The law expressly declares that a candidate disqualified by final judgment before an election cannot be voted for and votes cast for him shall not be counted. As such, Palilang is the only candidate and the duly elected mayor. The doctrine will apply in Bayaksan's favor, regardless of his intervention in the present case. If two conditions concur, the decision on Kait's disqualification remained pending on election day, May 10, 2004, resulting in the presence of two mayoralty candidates for Bugyas Benguet in the elections, and the decision on Kait's disqualification became final only after the elections. The next case is Panlaqui versus Comelec. The facts of the case, Nardo Velasco was born in Sasmuan to Filipino parents. He moved to the United States where he subsequently became a citizen. Upon Velasco's application for dual citizenship under RA 9225, he took his oath of allegiance to the Republic of the Philippines and returned to the Philippines. Velasco applied for registration as a voter of Sasmuan, which application was denied by the Election Registration Board. He thus filed a petition for the inclusion of his name in the list of voters before the MTC of Sasmuan, which reversed the ERB's decision and ordered his inclusion in the list of voters of Sasmuan. On appeal, the RTC reversed the MTC decision. Velasco filed a certificate for candidacy for mayor of Sasmuan. Mozart Panlaqui, another candidate for the said position, filed before the Comelec a petition to deny due course to and or to cancel Velasco's COC based on gross material misrepresentation as to his residency and consequently his qualification to vote. Velasco won in the elections. As the Comelec failed to resolve Panlaqui's petition prior to the elections, Velasco took his oath of office and assumed the duties of the office. Finding material misrepresentation on the part of Velasco, the Comelec canceled his COC and nullified his proclamation, which this court affirmed in GR number 180051. As such, Panlaqui filed a motion for him to be proclaimed as mayor, but the Commission on Elections and Bank dismissed the motion on the ground that the rule on succession does not operate in favor of Panlaqui as the second placer because Velasco was not disqualified by final judgment before the election day. Comelec then ordered Velasco to vacate his mayoralty post for the incumbent vice mayor to assume office as mayor. The issue in this case is whether or not the RTC decision in the voters' inclusion proceedings must be considered as the final judgment of disqualification against Velasco, which decision was issued more than 2 months prior to the elections. Whether or not it is proper for the Comelec to deny the proclamation of Panlaqui as mayor. So the ruling of the court is no. It is not within the province of the RTC in the voters' inclusion-exclusion proceedings to take cognizance of and determine the presence of a false representation of a material fact. It has no jurisdiction to try the issues of whether the misrepresentation relates to material facts and whether there was an intention to deceive the electorate in terms of one's qualifications for public office. The finding that Velasco was not qualified to vote due to lack of residency requirement does not translate into finding of deliberate attempt to mislead, misinform, or hide the fact, which would otherwise render him ineligible. Besides, when the RTC issued the decision, there was yet no COC to cancel, because Velasco's COC was filed only on March 28, 2007. For the second issue, the court ruled that yes, it is proper for the Comelec to deny Panlaqui's proclamation since Velasco's disqualification as a candidate had not become final before the elections. The Comelec properly applied the rule on succession. To simplistically assume that the second placer would have received the other votes would be to substitute our judgment for the mind of the voter. The second placer is just that, a second placer. He lost the elections, he was repudiated by either a majority or plurality of voters. To allow the defeated and repudiated candidate to take over the mayoralty despite his rejection by the electorate is to disenfranchise them through no fault on their part, and to undermine the importance and the meaning of democracy and the right of the people to elect officials of their choice. So thank you for listening. Let us now proceed to the next reporter.
Good day, I am Andrea Tizona, and I will be discussing cases regarding election contests and public officers, namely Garcia versus Comelec, Lorenzo versus Comelec, Tugade versus Comelec, Office of the President versus Calixto Cataquiz, and Magawisan versus Office of the Ombudsman. The first case is Garcia versus Comelec. The facts are: Petitioner Maria Angela Garcia and Jose Alejandro Payumo III were rival candidates for mayor of Dinalupihan, Bataan during the May 13, 2013 national and local elections. In the poll's conclusion, Garcia was proclaimed winner. Payumo was then given a certified copy of the printed Certificate of Canvass of Votes and Proclamation, or the printed COCP, bearing May 15, 2013 as the date of proclamation of the winning mayoralty candidate. On May 27, 2013, Payumo filed with the RTC an election protest, citing the alleged prevalence of fraud and irregularities in all the clustered precincts of Dinalupihan, coupled with the PCOS machine's unreliability, casting doubt on the results of the counting and canvassing of votes. As to the timeliness of the recourse, Payumo claimed that from May 15, 2013, the proclamation date appearing on the printed COCP, he had 10 days, or until May 25, 2013, within which to challenge the election results. He added that since May 25, 2013 falls on a Saturday, he filed his protest on the immediately succeeding working day, Monday, May 27, 2013. Garcia moved for the dismissal of Payumo's protest on the ground of prescription. She claimed that she was proclaimed mayor on May 14, not May 15, 2013, as indicated in the manual COCP issued by Dinalupihan's Municipal Board of Canvassers, or MBOC. She argued that the election protest was filed beyond the mandatory 10-day reglementary period for filing an election protest, which, as she claimed in this case, lasted only until May 24, 2013, a Friday. On July 1, 2013, the RTC heard the motion for preliminary determination of the affirmative defense of prescription, where members of the MBOC of Dinalupihan testified that Garcia was proclaimed on May 14, 2013 at around 5 p.m. Thereafter, the RTC dismissed Payumo's protest for being barred by the statute of limitations. In disposing the case, the trial court relied on the individual declarations of the chairman and the two members of the MBOC of Dinalupihan, Bataan, as well as on the manual COCP, as sufficient proof that Garcia's proclamation took place on May 14, 2013. Payumo then appealed the dismissal with the Comelec, which was granted. On reconsideration, the Comelec en banc affirmed the holding of the First Division and disposed Garcia's motion. Garcia now contends that the reckoning date of the 10-day reglementary period is from the actual date of proclamation, which is May 14, 2013. Meanwhile, Payuma counters that Garcia was proclaimed on May 15, 2013, and assuming arguendo that it was done on May 14, as Garcia insists the proclamation date to be, he cannot be faulted for relying on the date appearing on the printed COCP he received. So the issue in this case is whether or not Payumo's election protest is barred by the statute of limitations. The court ruled in the affirmative. Pivotal in resolving whether or not Payumo's election protest is barred by the statute of limitations is ascertaining when the MBOC proclaimed Garcia as the winning mayoralty candidate. The significance of verifying this proclamation date is underscored by Rule 2, Section 12, Paragraph C, in relation to Section 7 of the same rule, otherwise known as the 2010 Rules of Procedure in Election Contests before the courts involving elective municipal officials, which provisions state, "The court shall summarily dismiss motu proprio an election protest on the ground of the petition is filed beyond the period prescribed in these rules. The election protest or petition for quo warranto shall be filed within a non-extendable period of 10 days counted from the date of proclamation." Jurisprudence teaches that the rule prescribing the 10-day reglementary period is mandatory and that the filing of an election protest beyond the period deprives the court of jurisdiction over the protest. The rule is not a mere technicality but an essential requirement. The private parties herein advance two conflicting dates whence the reglementary period should recon. But between the two proposed reckoning dates, May 14, 2013, as claimed by petitioner, appears to be the correct date of proclamation. As can be recalled, the RTC has conducted a motion hearing to determine the timeliness of the election protest. During the said proceeding, the members of the MBOC testified that Garcia was proclaimed winner of the mayoralty race on May 14, 2013, not on May 15, 2013, as what erroneously appeared on the printed COCP. Additionally, the testimony of Lani Peñaflor, the vice chairperson of the MBOC, conveys an explanation for the discrepancy between the dates appearing on the manual and printed COCPs. Here, the procedure followed by the MBOC, as outlined by Peñaflor, is consistent with Comelec Resolution No. 9700. As aptly concluded by the RTC, the declaration made by the individual members of the MBOC that the proclamation of the private respondent was done on May 14, 2013, coupled with the issuance of the manual COCP on the same date, is sufficient proof that private respondent's proclamation was in fact done on May 14, 2013 and not on May 15, 2013. Having established that Garcia was proclaimed the winning mayoralty candidate on May 14, 2013, it is then plain to see that Payumo's election protest, dated May 27, 2013, was filed beyond the 10-day reglementary period and ought to be dismissed outright. The next case is Lorenzo versus Comelec. The facts are, petitioner Sonia Lorenzo and respondent Nestor Magno were rival candidates for mayor of San Isidro, Nueva Ecija, in the local elections of May 14, 2001. By virtue of a petition for disqualification, the Comelec 2nd Division disqualified respondent as a candidate on the ground of his conviction of 4 counts of direct bribery. This was affirmed on appeal by the Comelec en banc. Consequently, petitioner was proclaimed as the mayor-elect. Meanwhile, respondent filed a petition for certiorari before the Supreme Court, assailing his disqualification by the Comelec. Ruling in favor of Magno, the SC declared that Magno's disqualification ceased, and he was therefore under no such disqualification anymore when he ran for mayor of San Isidro. The SC also ruled that inasmuch as petitioner had already been proclaimed as the winning candidate, the remedy of respondent would have been a timely election protest. Respondent Magno then filed an omnibus motion for the Comelec seeking, among others, that a special board of canvassers be formed to continue the canvass of votes cast in favor of respondent Magno, and after completion of the canvass, that Magno be proclaimed the winner. Granting Magno's motion, the Comelec en banc ordered the immediate constitution of a new MBOC for the purpose of counting the votes cast for respondent. Hence, this instant petition for certiorari and mandamus, where petitioner argues that the Comelec's order for the canvass of votes defies the Supreme Court's previous ruling that Magno should have filed an election protest. So the issue in this case is whether or not the Comelec's order for the canvass of votes defies the Supreme Court's previous ruling that Magno should have filed an election protest. The court ruled in the negative. As a general rule, the proper remedy after the proclamation of the winning candidate for the position contested would be to file a regular election protest or a petition for quo warranto. This rule, however, admits of exceptions, one of which is where the proclamation was null and void. This case falls squarely within the fifth exception to the general rule. That is, the proclamation of Lorenzo as mayor of San Isidro was null and void. As of May 18, 2001, the date on which Lorenzo was proclaimed mayor-elect of San Isidro, the question as regards Magno's qualifications for said post was still pending and was raised as an issue before this court in certiorari proceedings. The question of Magno's qualification for the office of mayor was not resolved until October 4, 2002, when the court expressly ruled that Magno was qualified for said post. Since the question of Magno's eligibility for the position of mayor was still pending, the canvass, which excluded Magno from the list of qualified candidates, was an incomplete canvass, and Lorenzo's proclamation, on the basis thereof, was illegal. An incomplete canvass is illegal and cannot be the basis of a valid proclamation. Respondent Magno cannot be faulted for his failure to file an election protest. The question of his qualification or disqualification for the position of mayor had not yet been settled as of the expiration of the 10-day reglementary period. As such, Magno was not yet eligible to file an election protest, and therefore, the fact that no such protest was filed should not be an impediment to his proclamation as mayor if the results of the canvass of the new MBOC would show that he garnered the highest number of votes. The third case is Tugade versus Comelec. The facts are, Petitioner Edward Tugade and private respondent Lorenzo Agustin were candidates for the position of Punong Barangay of San Raimundo, Balongao, Pangasinan during the July 15, 2002 synchronized barangay and SK elections. The result of the canvass showed that petitioner obtained 246 votes, while private respondent garnered 245 votes, or a margin of only 1 vote. Hence, the Barangay Board of Canvassers proclaimed petitioner as the elected Punong Barangay. A week after the proclamation, Agustin filed with the MTC an election protest. After due trial, the MTC rendered its decision declaring private respondent the duly elected Punong Barangay. The MTC considered the review of the final tally of votes, including those in the contested precincts, where Agustin garnered 246 votes, while Tugade received 242. On appeal, the Comelec 2nd Division issued the assailed resolution declaring a tie between Agustin and Tugade, with both of them obtaining 246 votes, considering the validated claimed votes and invalidated votes. The Comelec also ordered the Barangay Board of Canvassers to reconvene for a special public meeting where there will be drawing of lots to determine who will be proclaimed Punong Barangay pursuant to Section 240 of the Omnibus Election Code or the OEC. Petitioner Tugade filed a motion for reconsideration with respondent Comelec and Bank. On January 5, 2006, petitioner's motion for reconsideration was denied due to his failure to file the motion within the 5-day reglementary period, among other reasons. This led Tugade to file the present petition on the ground that the Comelec's resolution and order are not in accord with the law or with applicable decisions. In his comment, private respondent contends that this petition should be dismissed because it does not allege facts showing grave abuse of discretion amounting to lack or in excess of jurisdiction on the part of respondent Comelec. So the issue in this case is whether or not the Comelec's resolution declaring a tie between Agustin and Tugade is in accordance with law and jurisprudence. The court ruled in the affirmative. Respondent Comelec and Bank, in ordering the immediate implementation of the resolution issued by its 2nd Division for the drawing of lots of the herein parties, acted in accordance with Section 240 of BP Bilang 881 or the Omnibus Election Code of the Philippines, which provides among others that whenever it shall appear from the canvass that 2 or more candidates have received an equal and highest number of votes, the Board of Canvassers shall hold a special public meeting at which the Board of Canvassers shall proceed to the drawing of lots of the candidates who have died, and shall proclaim as elected the candidates who may be favored by luck, and the candidate so proclaimed shall have the right to assume office in the same manner as if he had been elected by plurality of vote. Next is the case of Office of the President versus Calixto Cataquiz. This is a petition for review and certiorari filed by the Office of the President and the Presidential Anti-Graft Commission or PAGC against Calixto Cataquiz. Respondent Cataquiz was the former general manager of the Laguna Lake Development Authority or LLDA who was accused of corrupt and unprofessional behavior and management incompetence. In response, then DNR Secretary ordered the formation of an investigating team to conduct an inquiry into the allegations against Cataquiz. Thereafter, the investigating team recommended that the case be forwarded to the PAGC for proper investigation. After due investigation, the PAGC recommended that the penalty of dismissal from the service with the accessory penalties of disqualification for re-employment in the public service and forfeiture of government retirement benefits be imposed upon Cataquiz. The Office of the President adopted the findings of the PAGC and dismissed Cataquiz from the service. Cataquiz filed a motion for reconsideration and or for new trial. The OP then issued an amended resolution imposing on Cataquiz the penalties of disqualification from re-employment in the government service and forfeiture of retirement benefits, in view of the fact that the penalty of dismissal was no longer applicable to him because of his replacement as general manager of the LLDA. Cataquiz then elevated this case to the CA via a petition for review. In reversing and setting aside the amended resolution, the CA found that the offenses charged against Cataquiz constituted acts that were within his authority as general manager of the LLDA to perform. Not in conformity, the Office of the President and the PAGC filed this petition for review, alleging, among others, that the CA erred because its judgment is based on a misapprehension of facts. On the other hand, Cataquiz mainly argues that the dismissal by the Ombudsman of the charges against him serves as a bar to the decision of the Office of the President, and that his removal has rendered the imposition of the principal penalty of dismissal impossible. The issues in this case are whether or not the dismissal of the criminal case against respondent bars the finding of administrative liability, and whether or not removal or resignation from office is a bar to a finding of administrative liability and renders moot the penalty of dismissal. As to the first issue, the court ruled in the negative. Cataquiz claims that the dismissal by the Ombudsman of the case against him constitutes the law of the case between him and the Office of the President, which necessitates the dismissal of the petition before this court. The Ombudsman resolution recommending the dismissal of the charges against him pertains only to the criminal case against him and not the administrative case, which is the subject matter of the case at bench. As can be gleaned from the resolution, the charges referred to by the Ombudsman were for respondents' alleged violation of Section 3B and C of RA number 3019, or for malversation of public funds and fraud against the public treasury. It is a basic rule in administrative law that public officials are under a threefold responsibility for a violation of their duty or for a wrongful act or omission, such that they may be held civilly, criminally, and administratively liable for the same act. Obviously, administrative liability is separate and distinct from penal and civil liability. In the case of People v. Sandigan Bayan, the court elaborated on the difference between administrative and criminal liability. The distinct and independent nature of one proceeding from the other can be attributed to the following. First, the difference in the quantum of evidence required, and correlatively, the procedure observed and sanctions imposed. And second, the principle that a single act may offend against two or more distinct and related provisions of law, or that the same act may give rise to criminal as well as administrative liability. Accordingly, the dismissal of the criminal case by the Ombudsman does not foreclose administrative action against Cataquiz. His absolution from criminal liability is not conclusive upon the office of the President, which subsequently found him to be administratively liable. The pronouncement made by the Ombudsman cannot serve to protect the respondent from further administrative prosecution. A contrary ruling would be unsettling, as it would undermine the very purpose of administrative proceedings, that is, to protect the public service and uphold the time-honored principle that the public office is a public trust. As to the second issue, the court ruled in the negative. Despite his removal from his position, Cataquiz can still be held administratively liable for acts committed during his service as general manager of the LLDA, and he can be made to suffer the corresponding penalties. The subsequent finding by the Office of the President that Cataquiz is guilty of the charges against him, with the imposition of the penalty of dismissal and its corresponding accessory penalties, is valid. As Cataquiz was a presidential appointee, he was under the direct disciplining authority of the President, who could legitimately have him dismissed from service. Cataquiz argues that his removal has rendered the imposition of the principal penalty of dismissal impossible. Consequently, citing the rule that the accessory follows the principal, he insists that the accessory penalties may no longer be imposed on him. Instructive is the case of Pagano versus Nazaro Jr., where the court held that the instant case is not moot and academic, despite the petitioner's separation from government service. Even if the most severe of administrative sanctions, that of separation from service, may no longer be imposed on the petitioner, there are other penalties which may be imposed on her if she is later found guilty of administrative offenses charged against her, namely, the disqualification to hold any government office and the forfeiture of benefits. Based on the foregoing, it is clear that the accessory penalties of disqualification from re-employment in public service and forfeiture of government retirement benefits can still be imposed on the respondent. Hence, removal or resignation from office is not a bar to a finding of administrative liability. The last case I will be discussing is Bagawisan versus Office of the Ombudsman. The facts are, at the time material to this case, petitioner Dr. Ramil Bagawisan was the chief of Hospital 1 of the Cortes Municipal Hospital in Cortes, Surigao del Sur. By virtue of an anonymous letter alleging acts of nepotism committed by petitioner, a complaint affidavit was filed criminally and administratively charging petitioner with violation of Section 59, Chapter 8, in relation to Section 67, Chapter 10, Title 1A, Book 5 of EO 292, in grave misconduct. The complaint averred that petitioner's acts designating his wife, Nelita Bagawisan, or Nelita, as administrative officer and licensed officer of the Cortes Municipal Hospital, as well as internal control unit, in addition to her position as nutritionist dietitian 1, violated the rule against nepotism. In defense, petitioner claimed that the rule of nepotism does not prohibit designation. In its decision, the Ombudsman found that there was a flagrant disregard of Section 59, Chapter 8, Title 1A, Book 5 of EO 292 when petitioner designated his wife to other positions in the government, namely, administrative officer and licensed officer, as well as internal control unit. Petitioner's argument that the rule on nepotism prescribes only appointment and not designation is misplaced, as there is no distinction between them. Petitioner filed a motion for reconsideration, but the same was denied. On appeal, the CA affirmed the Ombudsman's ruling, finding him guilty of grave misconduct. Petitioner moved for reconsideration, which was denied by the CA. Hence, this petition. The issues in this case are whether or not petitioner is guilty of nepotism and whether or not petitioner's actions constitute grave misconduct. As to the first issue, the court ruled in the affirmative. Nepotism is defined in Section 59, Chapter 8, Title 1A, Book 5 of EO 292 as follows. All appointments in the national, provincial, city, and municipal governments or in any branch or instrumentality thereof, including GOCCs, made in favor of a relative of the appointing or recommending authority or of the chief of the Bureau of Office are hereby prohibited. As used in this section, the word relative and members of the family referred to are those related within the third degree, either of consanguinity or of affinity. Under the foregoing definition, one is guilty of nepotism if an appointment is issued in favor of a relative within the third civil degree of consanguinity or affinity of any of the following: A. Appointing authority, B. Recommending authority, C. Chief of the Bureau of Office, and D. Person exercising immediate supervision over the appointee. Jurisprudence has it that for the purpose of determining nepotism, there should be no distinction between appointment and designation. Otherwise, the prohibition on nepotism would be meaningless and toothless. Any appointing authority may circumvent it by merely designating, and not appointing, a relative within the prohibited degree to a vacant position in the career service. Here, it is undisputed that Nalita, the appointee, is the wife of petitioner, the appointing authority and chief of Hospital 1 of the Cortes Municipal Hospital. By virtue of his position, petitioner appointed Nalita as administrative officer and liaison officer, as well as internal control unit, in addition to her position as nutritionist dietitian 1 of the Cortes Municipal Hospital. Hence, petitioner is guilty of nepotism. Before I give the floor to Ms. Vista, the following are the case doctrines. First, in Garcia v. Comelec, the court has held that the election protest or petition for quo warranto shall be filed within a non-extendable period of 10 days counted from the date of proclamation. The rule prescribing the 10-day reglementary period is mandatory and jurisdictional, and that the filing of an election protest beyond the period deprives the court of jurisdiction over the protest. Second, in Lorenzo v. Comelec, the court has held that as a general rule, the proper remedy after the proclamation of the winning candidate for the position contested would be to file a regular election protest or a petition for quo warranto. This rule, however, admits of exceptions, to wit, 1. Where the board of canvassers was improperly constituted, 2. Where quo warranto was not the proper remedy, 3. Where what was filed was not really a petition for quo warranto or an election protest, but a petition to annul the proclamation, 4. Where the filing of a quo warranto petition or an election protest was expressly made without prejudice to the pre-proclamation controversy or was made ad coetelam, and 5. Where the proclamation was null and void. It is also important to note that an incomplete canvass is illegal and cannot be the basis of a valid proclamation. Next, in the case of Tugade v. Comelec, the court stated that to resolve the tie, there shall be drawing of lots. Section 240 of the Omnibus Election Code provides, whenever it shall appear from the canvass that 2 or more candidates have received an equal and highest number of votes, or in cases where 2 or more candidates are to be elected for the same position, and 2 or more candidates receive the same number of votes for the last place in the number to be elected, the Board of Canvassers, after recording this fact in its minutes, shall by resolution, upon 5 days' notice to all the tied candidates, hold a special public meeting at which the Board of Canvassers shall proceed to the drawing of lots of the candidates who have tied, and shall proclaim as elected the candidates who may favored by luck, and the candidates so proclaimed shall have the right to assume office in the same manner as if he had been elected by plurality of votes. The Board of Canvassers shall forthwith make a certificate stating the name of the candidate who had been favored by luck and his proclamation on the basis thereof. Nothing in this section shall be construed as depriving a candidate of his right to contest the election. Next, in the case of Office of the President versus Calixto Cataquiz, the court has held that public officials are under a threefold responsibility for a violation of their duty or for a wrongful act or omission, such that they may be held civilly, criminally, and administratively liable for the same act. As such, administrative liability is separate from and independent of criminal and civil liability. Also, removal or resignation from office is not a bar to a finding of administrative liability. Lastly, in the case of Pagawisan versus Office of the Ombudsman, the court stated that one is guilty of nepotism if an appointment is issued in favor of a relative within the third civil degree of consanguinity or affinity of any of the following: A. Appointing authority, B. Recommending authority, C. Chief of the Bureau or Office, and D. Person exercising immediate supervision over the appointee. It is also important to note that for the purpose of determining nepotism, there should be no distinction between appointment and designation. Otherwise, the prohibition on nepotism would be meaningless and toothless. Any appointing authority may circumvent it by mere designating and not appointing a relative within the prohibited degree to a vacant position in the career service. Section 59, Book 5 of EO 292 means exactly what it says in plain and ordinary language. It refers to all appointments, whether original or promotional in nature.
Now we move forward to the last cases on public officers and administrative law. So we have 4 cases to be discussed. First is Yangson versus Department of Education. Second is Magamit versus Internal Affairs Services Philippines Drug Enforcement Agency. Third is International Container Terminal Services Incorporated versus City of Manila. And lastly is Saonar versus Ermita. To start with Yangson versus Department of Education, the case doctrine is reassignments differ from transfers, and public employees with appointments that are not station specific may be reassigned to another station in the exigency of public service. So the facts are as follows. Marilyn R. Yangson was the principal 3 at the Surigao Norte National High School. On April 30, 2008, Yangson was personally served a memorandum dated April 14, 2008, issued by then Assistant Schools Division Superintendent Officer in Charge, Fidela Rosas. In the memorandum, Yangson was reassigned from Surigao National to Toledo S. Pantelo Memorial National High School, purportedly due to the exigency of service effective May 5, 2008. She was also directed to submit her clearance as to money and proper accountability before reporting to the Toledo Memorial. However, Yangson refused to accept the memorandum without first consulting her counsel. 2 days prior to the activity of her reassignment, on May 5, 2008, Yangson filed before the RTC a petition for injunction with prayer for temporary restraining order and damages against Rosas and Dulcissima Corvera, who was supposed to replace Yangson as the new principal of Surigao National. Yangson alleged that the memorandum violated Department of Education Circular Number 2, Series of 2005, because it failed to specify the duration of her reassignment and because it was issued without her prior consultation. She also claimed that there was no vacancy in the position and the reassignment would cause diminution in her rank. So the decision of the lower courts are as follows. On May 5, 2008, the RTC issued a TRO. However, in its May 24, 2008 order, the RTC denied Yangson's prayer for preliminary injunction. It held that Yangson did not have a vested right over her position at Surigao National because her appointment as Principal 3 was not station-specific. It also found that the RTO was sufficient to vindicate her rights even if the memorandum was not served properly. Furthermore, the trial court ruled that Yangson was not singled out as other principals were also reassigned. It held that the reassignments were in good faith and within Rosa's authority. Thus, Yangson appealed before the Department of Education Caraga Regional Office. In her June 11, 2008 resolution, Regional Director Jesusita Arteche denied Yangson's appeal, citing Section 26 of the Administrative Code, which differentiated transfers from reassignments. She found that Yangson was reassigned, not transferred. Thus, Section 6 of the Magna Carta for Public School Teachers, which only provided for transfers, was inapplicable. Yang Son's reassignment then could not be held in abeyance while her appeal was pending resolution. Yang Son elevated her case to the Department of Education Central Office, but her appeal was denied in the August 13, 2008 resolution. The Department of Education Central Office affirmed that Yang Son was reassigned and not transferred since her movement did not involve the issuance of an appointment. It held that since Yang Son's appointment was not station specific, her reassignment was within the prerogative of the head of office for the exigency of service. Hence, Yang Son could be assigned to any school. She then elevated her claims to the Civil Service Commission, which reversed both resolutions of the Department of Education Central Office and ruled in favor of Yang Son. It found that her reassignment did not comply with the requirements of Section 6 of the Magna Carta for public school teachers. Thus, the Department of Education elevated the matter to the Court of Appeals. In its July 28, 2011 decision, the Court of Appeals set aside the rulings of the Civil Service Commission. The Court of Appeals maintained that while reassignments are different from transfers, both are covered by Section 6 of the Magna Carta for public school teachers. However, though it was applicable, the Court of Appeals found that the provision was not violated. It explained that Yang Son was being reassigned under the division's office plan to reshuffle school administrators in the exigency of service, as the last reshuffling had happened more than 5 years earlier. So the main issue in this case is that whether the Court of Appeals did not address the issue of whether herein petitioner's movement was a reassignment or a transfer. The decision of the Supreme Court states that the petition lacks merit. The petitioner's reassignment is actually valid. This court affirms the finding that petitioner's appointment was not station specific. An appointment is station specific if the employee's appointment paper specifically indicates on its face the particular office or station the position is located. Moreover, the station should already be specified in the position title, even if the place of assignment is not indicated on the face of the appointment. Evidently, petitioner's appointment is not solely for Surigao National or for any specific school. There is no particular office or station specifically indicated on the face of her assignment or appointment paper. Neither does her position title specifically indicate her station. In the case of Osea versus Malaya, it differentiates a reassignment from a new appointment, which is necessary in a transfer. It states that appointment should be distinguished from reassignment. An appointment may be defined as the selection by the authority vested with the power of an individual who is to exercise the functions of a given office. When completed, usually with its confirmation, the appointment results in security of tenure for the person chosen unless he is replaceable at pleasure because of the nature of his office. On the other hand, a reassignment is merely a movement of an employee from one organizational unit to another in the same department or agency, which does not involve a reduction in rank, status, or salary and does not require the issuance of an appointment. In Department of Education, Culture, and Sports versus Court of Appeals, a secondary school principal whose appointment was not station specific contested her reassignment to another school. She cited that the Magna Carta for public school teachers arguing that her consent is necessary for the reassignment's validity, which was not affirmed by the Supreme Court. Hence, the court denied the petition in this case. Going to the second case, Magkamit versus Internal Affairs Services, the Philippines Drug Enforcement Agency or PDEA. In a letter dated April 13, 2008, addressed to a Director General Janicio R. Santiago, a person named Delphine gave information about an alleged extortion done to his mother by Magkamit and other PDEA agents. The PDEA agents denied the irregularities imputed to them and maintained that the letter complaint was made only to destroy their reputation. On May 5, 2008, Magkamit and his co-agents, namely Carlo Aldeon, Renato Infante, Ryan Alfaro, and Apolinario Matyong Jr. were formally charged with grave misconduct for demanding and or obtaining 200,000 from Luciana M. Haen in exchange for her release after she was apprehended in a buy-bust operation in Lipa City. After they had submitted their answer, their case was submitted for recommendation and action. In a memorandum dated May 20, 2008, Special Investigator Romeo Enriquez found Magkamit and his co-agents liable for grave misconduct and recommended that they be dismissed from civil service accordingly. So they were dismissed on June 5, 2008. Now, the main issue in this case is whether or not the letter is sufficient to initiate the administrative complaint against the petitioner. It held that the Supreme Court is ruling in negative. Although Magamit assails that the letter complaint should not have been entertained to begin with, as it was not in accord with the revised rules on administrative cases in the civil service. They do not find any need to dwell on this point. The administrative complaint was initiated when Haen and Delphine executed sworn statements and filed them with the IAS PDEA. As the Court of Appeals correctly pointed out, the letter complaint did not by itself commence the administrative proceedings against Magkamit. It merely triggered a fact-finding investigation by the IAS PDEA. Accordingly, these sworn statements together with the letter complaint were used as pieces of evidence to build a prima facie case for extortion warranting a formal charge for grave misconduct. Administrative determinations of contested cases are by their nature quasi-judicial. There is no requirement for strict adherence to technical rules that are observed in truly judicial proceedings. As a rule, technical rules of procedure and evidence are relaxed in administrative proceedings in order to assist the parties in obtaining just, speedy, and inexpensive determination of their respective claims and defenses. By relaxing technical rules, administrative agencies are thus given leeway in coming up with a decision. Nonetheless, in deciding disciplinary cases pursuant to their quasi-judicial powers, administrative agencies must still comply with the fundamental principle of due process. Administrative tribunals exercising quasi-judicial powers are unfettered by the rigidity of certain procedural requirements subject to the observance of fundamental and essential requirements of due process in justiciable cases presented before them. Third case is the International Container Terminal Services Incorporated versus City of Manila. The case doctrine is the doctrine of exhaustion of administrative remedies requires a party to resort to an administrative remedy before seeking relief from the court. However, if a party can prove that resorting to an administrative remedy would be an idle ceremony and that relief will not be granted, then the doctrine does not apply. This case involves a dispute between International Container Terminal Services Incorporated and the City of Manila regarding the imposition of local business taxes. International Container claimed that the City of Manila committed direct double taxation by imposing a local business tax in addition to the business tax already imposed. The Court of Tax Appeals Second Division partially granted International Container's claim for a refund of the erroneously paid business taxes for the third quarter of 1999. However, it did not order a refund for the business taxes paid by International Container subsequent to the first 3 quarters of 1999. International Container appealed the decision to the Court of Tax Appeals en banc, which dismissed the petition for lack of merit. Now, there are 2 issues in this case. First is whether or not Section 195 or Section 196 of the Local Government Code govern petitioners International Container Terminal Services Incorporated's claim for refund from the 4th quarter of 1999 onwards, and second, whether or not International Container complied with the requirements for refund under Section 196. Now, for the first ruling, Section 196 should be applied. Sections 195 and 196 of the Local Government Code govern the remedies of a taxpayer for taxes collected by local government units except for real property taxes. Hence, the first provides the procedure for contesting an assessment issued by the local treasurer, whereas the second provides the procedure for the recovery of an erroneously paid or illegally collected tax, fee, or charge. Both Sections 195 and 196 mention an administrative remedy that the taxpayer should first exhaust before bringing the appropriate action in court. In Section 195, it is the written protest with the local treasurer that constitutes the administrative remedy. While in Section 196, it is written claim for refund or credit with the same office. If no assessment notice is issued by the local treasurer and the taxpayer claims that it erroneously paid a tax fee or charge or that the tax fee or charge has been illegally collected from him, then Section 196 applies. Here, no notice of assessment for deficiency taxes was issued by respondent city treasurer to petitioner for the taxes collected after the first 3 quarters of 1999. Hence, Section 195 of the LGC cannot apply to the period because to the subsequent to the third quarter of 1999, because International Container did not receive any notice of assessment thereafter that states the nature of the tax, amount of deficiency, and charges. Ruling to the second, the Supreme Court said yes, to be entitled to a refund under Section 196 of the Local Government Code, the taxpayer must comply with the following procedural requirements. First, there must be a written claim for refund or credit with the local treasurer. And second, file a judicial case for refund within 2 years from the payment of the tax fee or charge or from the date when the taxpayer is entitled to a refund or credit. As to the first requirement, the records show that International Container made the written claims for refund to the city treasurer. As for the taxes paid thereafter and were not covered by the letters, the court ruled that the doctrine of exhaustion of administrative remedies can be dispensed with in this case. If the party can prove that the resort to the administrative remedy would be an idle ceremony such that it will be absurd and unjust for it to continue seeking a relief that evidently will not be granted to it, then the doctrine would not apply. Here, the court agreed with International Container that repeated filing of written claims would yield the same result. This is bolstered by Respondent City Treasurer September 1, 2005 letter, in which it stated that it could not act favorably on petitioners' claim for refund until there would have been a final judicial determination of the invalidity of Section 21A. Similarly, petitioner complied with the second requirement under Section 196 of the Local Government Code that it must file its judicial action for refund within 2 years from the date of payment, or the date that the taxpayer is entitled to the refund or credit. Among the reliefs it sought in its amended and supplemental petition before the RTC is the refund of any and all subsequent payments of taxes under Section 21A from the time of the filing of its petition until the finality of the case. The last but not the least is Saonor versus Ermita. In this case, Saonor was a former regional director of NBI. Through the years, he rose from the ranks and eventually became the chief of the anti-graft division. During his time as chief of the said division, Saonor conducted an official investigation regarding the alleged corruption relative to the tobacco excise taxes and involving then Governor Luis Chavez Singson, former President Joseph Estrada, and former Senator Jenggoy Estrada. President Estrada assailed involvement in the tobacco excise tax issue became one of the predicate crimes included in his indictment for plunder. In Special Order Number 4003 dated August 27, 2004, Saonor was reassigned as Regional Director for Western Mindanao based in Zamboanga City. During his stint as such, he received a subpoena ad testificandum from the Sandigan Bayan requiring him to testify in the plunder case against President Estrada. After securing approval from his immediate supervisor, Saonor appeared before the Sandigan Bayan on several hearing dates, the last being October 27, 2004. On October 29, 2004, then NBI Director Reynaldo Waicoco issued Special Order Number 5033 informing Saonor that he was relieved from his duties as Regional Director for Western Mindanao and was ordered to report to the DDROS for further instructions. Pursuant thereto, he reported to Bautista on the first week of November 2004. Bautista informed Saonor that an investigation was being conducted over his testimony before the Sandigan Bayan and that he should just wait for the developments in the investigation. In the meantime, Bautista did not assign him any duty and told him to be available at any time whenever he would be needed. He made himself accessible by staying in establishments near the NBI. In addition, he also attended court hearings whenever required. On October 6, 2006, Saonar received an order from the Presidential Anti-Graft Commission requiring him to answer the allegations against him in the PAGC formal charge dated October 3, 2006. The charge was based on a letter from Mekoko reminding an immediate appropriate action against Saonar for his failure to report for work since March 24, 2005 without approved leave of absence for 4 months. On October 23, 2006, Saonar was reassigned as Regional Director of the Bicol Regional Office. On January 9, 2007, he received a copy of the OP decision dismissing him from service. The OB found Saonar guilty of gross neglect of duty and of violating Section 3E of RA number 3019 and dismissed him from service. It pointed out that Saonar failed to report for work for more than a year, which he himself admitted when he explained that he did not report for work because he had not been assigned any specific duty or responsibility. The OP highlighted that he was clearly instructed to report to the DDROS, but he did not do so. It added that it would have been more prudent for Saonar to have reported for work, even if no duty was specifically assigned to him, for the precise reason that he may at any time be tasked with responsibilities. The OP, however, absolved Saonar from allegedly keeping government property during the time he did not report for work, noting that he was able to account for all the items attributed to him. The CA affirmed in toto the OP's decision. The appellate court ruled that Saonar was not deprived of due process because he was informed of the charges against him and was given the opportunity to defend himself. It expounded that the absence of formal hearings in administrative proceedings is not anathema to due process. On the other hand, the CA agreed that Saonar was guilty of gross neglect of duty as manifested by his being on absence without leave for a long period of time. The appellate court disregarded Saonar's explanation that he stayed in establishments nearby and that he had attended court hearings from time to time. In addition, the CA found that Saonar violated Section 3 of RA number 3019 because public interest was prejudiced when he continued to receive his salary in spite of his unjustified absences. Now, the main issue is whether the Court of Appeals erred in ruling that petitioner was not denied due process and that respondents did not violate petitioner's right to security of tenure as guaranteed in the Constitution. This decision of the Supreme Court says that yes, the petition is actually meritorious. Under the PAGC rules of procedure, it is crystal clear that the conduct of clarificatory hearings is discretionary. Nevertheless, in the event that it finds a necessity to conduct one, there are rules to be followed. 1, the parties are to be notified of the clarificatory hearings. 2, the party shall be afforded the opportunity to be present in the hearings without the right to examine witnesses. They, however, may ask questions and elicit answers from the opposing party course through the PAGC. To reiterate, due process is a malleable concept anchored on fairness and equity. The due process requirement before administrative bodies are not as strict compared to judicial tribunals in that it suffices that the party is given a reasonable opportunity to be heard. Nevertheless, such reasonable opportunity should not be confined to the mere submission of position papers and or affidavits, and the parties must be given the opportunity to examine the witnesses against them. So the right to a hearing is a right which may be invoked by the parties to thresh out substantial factual issues. It becomes even more imperative when the rules itself of the administrative body provides for one. While the absence of a formal hearing does not necessarily result in the deprivation of due process, it should be acceptable only when the party does not invoke the said right or waives the same. The court finds that Saonar was not treated fairly in the proceedings before the PAGC. He was deprived of the opportunity to appear in all clarificatory hearings since he was not notified of the clarificatory hearing attended by an NBI official. Saonar was thus denied the chance to propound questions through the PAGC against the opposing parties when the rules of the PAGC itself granted Saonar the right to be present during clarificatory hearings and the chance to ask questions against the opposing party. So again, we must bear this in mind that thus administrative bodies should not simply brush aside the conduct of formal hearings and claim. The due process was observed by merely relying on position papers and or affidavits. Besides, the court in Jason recognized the inherent limitations of relying on position papers alone, as the veracity of its contents cannot be readily ascertained. Through the examination and cross-examination of witnesses, administrative bodies would be in a better position to ferret out the truth and in turn render a more accurate decision. To reiterate again, due process is a malleable concept anchored on fairness and equity. The due process requirement before administrative bodies are not as strict compared to judicial tribunals, in that it suffices that a party is given a reasonable opportunity to be heard. Nevertheless, such reasonable opportunity should not be confined to the mere submission of position papers and or affidavits, and the parties must be given the opportunity to examine the witnesses against them. The right to a hearing is a right which may be invoked by the parties to thresh out substantial factual issues. It becomes even more imperative when the rules itself of the administrative body provides for one. While the absence of a formal hearing does not necessarily result in a deprivation of due process, it should be acceptable only when the party does not invoke the said right or waives the same. Hence, the petition here of Saonar is granted by the Supreme Court. Thank you for listening, and we hope that you've learned a lot in our session for today.